Good afternoon. Hope you are doing well. Welcome to our today's session on judiciary, an important organ of modern state mechanism. We are aware that during the formation of modern nation state mechanism, the majority of the countries they have incorporated international charters, treaties, declarations in their constitution to safeguard the rights of its own citizenry. See, the constitution of Bangladesh, large chunk of the constitution deals with the uh, uh, human rights of its own citizenry. So to look after the human rights and to uphold the rule of law within the society, judiciary is an important organ of modern nation state mechanism. Today's class will discuss the idea of the laws, the types of the laws, then we will highlight the structure of modern judiciary within the modern nation state mechanism. Then we'll discuss the appointment of the judges in the judiciary. We'll talk about the separation of power between judiciary and executive. And finally, we'll talk about the issues related with political role of the court within modern nation state mechanism. Types of law, we are aware that laws, it can be free modern, common law, code law, various kinds of laws. Criminal law, civil law. Mostly we are familiar with these two kinds. Apart from these kinds, laws are constitutional law, administrative law, international law. We will discuss in detail. Criminal law mostly deals with criminal offenses. It is statutory and covers a specific category of wrongs that are considered social evils and threat to the community. Criminal offenses, it could be petty offenses. Think about someone violated the traffic rules. What will happen? The punishment would be a small amount of fine or something like this. Criminal offenses could be serious but not major offenses such as gambling, prostitution. Criminal offenses could be major offenses such as think about the murder, rape, extortion. Within Bangladesh legal tradition, criminal law is mostly treated as whether it is cognizable or non-cognizable. Which one is the cognizable offense? Yeah. You think someone already hampered. So how can we define it is cognizable? So if we can see any strong evidences, think about someone murdered or someone raped. Through various kinds of evidences or various kinds of issues, we can easily identify, okay, it is cognizable. We can easily it makes sense, something happened here. We can easily understand it. And non-cognizable one, which we are not sure, I mean, how, why, I mean, actually how it happened. So think about someone just slapped me. So slapping, it is not something, I mean, it is not something cognizable. How can you show your slapping in front of others? So this is the non-cognizable offense. Within modern nation state mechanism, it is the state, not the victim. Try to remind that. It is the state, is the prosecutor of the criminal cases. Why not the victim? Why the state? Because state is the contract. So state is the contract. What kinds of contract? Is the contract to safeguard its own citizenry. So if someone hampered within a society, it is the cohesion, it is the solidarity, it is the rule of law of a specific society hampered. That is why a state prosecute the criminal cases within the modern nation state mechanism. Okay. Then civil law. Civil law mostly deals with issues related with marriage, divorce, inheritance, properties, contracts, bankruptcy, land-related issues. So if someone violates these kinds of laws, punishment money would be in terms of monetary, not in terms of imprisonment. So think about the issues related with marriage and maintenance, divorce and maintenance. Think about the issues related with land-related disputes. So, so these are the civil law. Then constitutional law which grows out of a country's basic documents. So think about myriad kinds of issues which are not available within, which is not statutory and which is not still codified, which is not think about not formulated through the legislature. So these kinds of laws mostly derived from the interpretation of the constitution and from the jurisdiction of the Supreme Court of a specific country. In majority of the countries, ultimate responsibility of interpreting the constitution rests with the Supreme Court. So many Supreme Court verdicts became the constitutional law. Think about within the Bangladeshi context. 3 to 4 years back, the Chief Justice of Bangladesh articulated about the life imprisonment. He argued that life imprisonment, it is something imprisonment until his or her death. But just in last week, what we have noticed that life imprisonment, it doesn't mean যে তোমার হচ্ছে imprisonment up to death, rather 30 years or something like that, except those who have convicted for war crimes or something else. That is different thing. We are not talking about it. But interesting thing is that think about I'm just describing another example of United States. In 1896, the USA court, it declared that state laws requiring racial segregation in public transportation did not necessarily violate the 14th Amendment. You know, during 18th and 19th century, there was public segregation within the public transportation of the US. People with color, that means African American, they are mostly segregated within the public transportation. They are not able to sit within certain kinds of seats, and these are only booked for the white people, or something like this. And when someone sued a case against this kind of policy in the court, and they argued that through the 14th Amendment of the US Constitution, it argued that it will ensure the equality before the law. During the hearing, the US court, it declared that this kind of segregation, it doesn't necessarily violated the principle of the equality. But what happened in 1954? The court reversed itself and ruled that separate public schools, separate segregation in the public transportation for whites and African Americans are inherently equal, and even if physically alike. So think about in 1896, the same court within the same legal landscape, it declared that it is not something the violation of the equality principle, but in 1954, near about 160 years, it argued that, oh, okay, this is not correct. So the thing is that constitution didn't change, but society's conception of individual rights did. So constitutional law is not static, but a living, growing institutions. Okay. Then administrative law. So which one is the administrative law? Immediate kinds of laws. Think about within the Bangladeshi context. Within the judicial vocabulary, which prohibits unfair and deceptive acts within the commerce. But what business practices are unfair and which one is deceptive? It is not well articulated. But several kinds of administrative agencies, they have interpret and they have develop certain kinds of rules and regulations through which they mitigate the problem. So these kinds of issues, these kinds of laws are the administrative laws. Within the Bangladeshi context, you will see administrative tribunal. It mostly deals with labor-related issues and labor-related the cases. Then international law. So international law, think about international court, international criminal court. I don't know whether you are aware with Rome Statute of 1998. Myriad kinds of international laws already developed, and many countries, they are obliged to follow the international laws. Already United States has Supreme Court order its own government to uphold the declarations and decisions it ratified with international bodies. Okay, then primitive law versus modern law. So think about what is the modern law. The laws mostly formulated and developed during the modern period, during the colonial period and following the colonial period. Primitive law, the laws which formulated before the colonial modern age. Higher law, mostly religious kinds of law. Natural law, mostly which automatically created within naturally. People automatically. So someone murdered someone. So it is something. Oh my God, this is something the violation. This is something. It is something deviation within the society. So that those kinds of things naturally, when people treated it something as crime. Common laws versus court law. Common laws, I mean, it was the laws during 14, 16 Middle Ages. Common laws, this is the common sense. Think about few common sense traditions within a specific community, the practices which became the issues of the law. And code law, mostly the laws which are codified. So what is codified? So think about all laws in Bangladeshi context, mostly are the codified law. What is the codification? Codification means that when which one is the crime, you have already defined it. Okay, this thing means this kind of crime. So if someone violates this kinds of thing, he or she will be punished this kinds of thing. So you have already codified what it means to be the crime, what actually the punishment of this kinds of crime, blah blah blah. And think about the common law, they don't have any codification. They actually, so they usually judge something based on common sense, traditional practices, and so on. Okay. Now the judicial structure in Bangladesh. Judiciary of Bangladesh consists of two of the Supreme Court and the subordinate court mostly. Subordinate court, many of us we read it as something district court. In Western societies, the court system different. Think about within the Indian context, think about the American context, they have federal court and they have the Supreme Court. But in Bangladeshi context, we don't have any federal courts. Rather, we have subordinate courts, which many of us, we read it, which is something misleading. This is not the district court, rather subordinate court. And Supreme Court, it is also divided in two parts. One is the High Court division and another one is the Appellate division. Okay. Mostly the Appellate division is the apex court, and its jurisdiction extends to hearing and determination of appeals from judgments, decrees, order, or sentences of High Court division. Appellate division in other cases, in addition to the above, may be vested in it by Act of Parliament. And think about the judicial court, pardon. The subordinate courts, it broadly divided in two parts. What kind of parts? Subordinate court. One is the civil court and another one is the criminal court. So criminal court, there are within the criminal court, there are court of session judge, court of the magistrate. Magistrate could be metropolitan magistrate, senior judicial magistrate, junior magistrate, various kinds of magistrate. So in terms of criminal cases, the magistrate, such as senior judicial magistrate and so on, they cannot, they cannot punish someone more than 5 years and 5 years of imprisonment or so on. So, so the major offenses such as crime, such as murder, such as rape, and other kinds of major offenses, which mostly the punishment of those cases mostly could be life imprisonment, even the death penalty, or imprisonment of more than 5 years. These kinds of cases mostly conducted within the session judge court. And within the civil court, there are court of district judge, court of the additional judge, court of the subordinate judge, court of the assistant judge. And interestingly, the district judge, the additional judge, they can also be the session judge. Okay, so so Bangladeshi subordinate court, so mostly deal with two things: criminal and civil. The appointment of the judges. In Bangladeshi context, president appoints someone to become the chief justice. The other judge is appointed by the president after consultation with the chief justice. to become the judge of High Court, someone needs two kinds of credentiality. Yeah. They should have 10 years experience of advocateship at High Court, or 10 years of uh, 10 years experience of judgeship at district court or session court. Okay. So in Bangladeshi context, it is important to discuss about the separation of power. In Bangladeshi context, though, in the constitution, it articulated that judiciary will be independent and it will be free from executive decision and so on. But there are problems within the notion of separation of judiciary in the Bangladeshi context, actually within South Asian context. In 2007, following the case of Mazdar Hussain case in Bangladeshi context, in 2007, yes, 2007, the judiciary became independent and it separated from the executive, but still there are issues within the notion of the separation, such as think about the appointment. We have already talked about that the appointment of the judges, it is really issue of serious issue of concern within the Bangladeshi context. Think about who will appoint and what are the credentialities to be the judges in Bangladeshi context. In Bangladeshi context, in majority of the cases, it seems that judges, they could be they could be appointed through the decision of president, and also the political intervention in appointment process. Problems within the colonial structure. Think about the subordinate court. In majority of the subordinate court, not only in the Bangladesh, in other parts of the South Asia, it assumed that following the colonial structure, as the continuation of the colonial structure, because during the colonial time, the subordinate judges, they are mostly treated as someone civil servant. So it really tough to discern the subordinate judges from other kinds of civil servants within the colonial structure. So the structure is still perpetuated in such a way, despite separated from executive, still there are blur areas within this thing. Though we treat the judiciary as separate organ, interestingly, the judiciary mostly dependent on executive related with financial issues. So, so in terms of their remuneration, in terms of their appointments, in terms of their infrastructural development, for everything they need to ask money from the executive, which create really problem in the judiciary. I am highly encourage you to listen the webinar conducted in our AND 355 course. There was a judge from Feni Judicial Court. I'm highly encourage you to watch that to understand the state, the problems, issues with Bangladeshi judiciary. Judiciary is not out of political control, political debates in Bangladeshi context. Think about sometimes judiciary create political concern within the society. So think about the case of Fifth Amendment. Think about when Supreme Court of Bangladesh it ordered the Fifth Amendment as something illegal. Think about what kinds of crises it created within the political context of the Bangladesh. And think about when it ordered the abolishment of the caretaker government. Through these kinds of issues, the whole political scenario of Bangladesh mostly changed. Myriad of kinds issues. In many cases, Supreme Court create, not only the Supreme Court, many court, they create the kinds of political debates within the society. So I highly encourage you to please listen the webinar, as well as please read the chapter 4 of Proskin's book for this thing. Thank you so much.